All right, picking up from the last video, we left off on the U.S. model characteristics and labor markets, major regulatory movements. So there's two movements we want to focus on in this class. The first is the National Labor Relations Act of 1935, also known as the Wagner Act. This was one of FDR's New Deal programs that was designed to help us recover from the Great Depression. And this one in particular was designed to empower workers with the support of the federal government. It represented a union bill of rights. It provided a framework for workers to unionize in the workplace. It investigated unfair labor practices and established the National Labor Relations Board. The NLRB was established to essentially serve as a means to unionize. So one of the issues prior to the Wagner Act was if you were going to unionize, if you were a worker and you were going to unionize in a firm, you ran the risk of getting terminated. Firms didn't want, potential unions because they knew that was going to monopolize their labor. It was going to raise the price of labor and ultimately hurt profitability. So if you were one of those people that was pro-union, you might have a hard time keeping your job. So the National Labor Relations Board was going to be a mechanism for you to create this union movement. So what you would do is you would apply with the National Labor Relations Board. They would then determine if there was enough support within that firm through voting for a union, and if there was, they would hold the vote. So it kind of relieved the individual that was spearheading, the individual employee that was spearheading the unionization from being, earmarked for termination. It also increased the amount of unionization that took place for obvious reasons. The second major movement is the Fair Labor Standards Act of 1938. This one is probably the most famous. In fact, there's no doubt you guys know some of these policies that came out of this act. The minimum wage. The minimum wage in 1938 was 25 cents. It's only went up since then. Now, we're talking about the federal minimum wage here. There have been state minimum wages after this as well. Overtime pay, and getting paid, time and a half or double time based on the amount of hours you work. That was almost unheard of prior to the Fair Labor Standards Act of 1938. Now it's commonplace. Record-keeping requirements, clocking in, clocking out, forcing employers to keep track of how many hours their employees work. We take it for granted that they do this, but part of it is to abide by the Fair Labor Standards Act of 1938. And then banning child labor. Child labor in the U.S. now means under 16. It's hard to know what the true motive for these policies were. Some people will say that we started caring ethically about workers in this period. That's possible, but it's also possible that we were trying to create jobs to help alleviate the distress of the Great Depression. And these policies do that. For example, the minimum wage makes lower productivity workers very expensive compared to what they can produce, and sometimes leads to less opportunity for them, freeing up jobs for higher productivity workers. Overtime pay makes employing somebody over 40 hours significantly more expensive. And so you don't want to employ someone over 40 hours, meaning let's say you have a firm that has 2 workers and they're currently working them 60 hours a week. Well, once the Fair Labor Standards Act hits, they're not going to want to employ them 60 hours anymore. They're going to take them down to 40 and essentially free up 40 hours and hire a third person. And then there's the direct effect of banning child labor, which removes children as substitutes or competition for adult workers. Let's talk about unions. Unions are an organization of workers in a company that come together for the purposes of improving conditions of work and pay. It's a way for workers to unite and collectively bargain for their compensation package and all amenities associated with the job. Union does empower the workers. It often leads to higher wages. It sometimes leads to less employment, but for those workers that do keep their jobs and are unionized, it's usually a win. And it's no different than any other type of supply side power, market power. Anytime you have less competition, you're able to drive up the price of whatever you're selling. And that's what workers would be doing. They'd be reducing the competition by coming together as one and negotiating collectively, and therefore they're able to command a higher price for what they're selling, their time. Membership for unions peaked in the 1950s. It's over 1/3 of the labor force, but it's declined since. Today, unions make up around 10% of the entire labor force. So relatively small percentage compared to many other countries, in particular in Europe, which we'll see later. The US has much lower membership than many other industrialized countries, but the details here matter. In the US, public sector unionization is much more likely than private sector unionization. So if you are unionized, there's a good chance you work for the government, not a private business. Whereas there's a little bit more balance in some of the other countries in Europe that have more overall unionization. So that 10% number is a little bit distorting because it's suggesting that 1 in 10 workers is unionized. But that's going to be different if you're in the public sector versus the private sector. There's also no successful union labor party in the US. If you think about the United Kingdom, where the two biggest parties are the Labour Party and the Conservatives. So there's a party dedicated to workers and fighting politically on behalf of those workers. We don't have that in the US. We have the Democrats, we have the Republicans, and both of those parties are more multifaceted. They're not catering solely to workers. If you had to choose one today, it would probably be the Democratic Party that is more ideologically consistent with the Labour Party in the UK. And more likely to take on the same kind of perspectives politically that union parties do in Europe. But the Democratic Party has a lot of other goals as well. It's not just labor that they're focused on, and that can change. Republican and Democrats in the U.S., those are titles attached to empty vessels. These vessels change throughout time based on the political climate. And the unions in the US are generally very small federations. Now, these unions do consolidate under big national organizations, so 80% of all unions, as small as they may be, as few workers as they may be representing, they're under this umbrella of AFL-CIO. So, for example, I'm part of a union for teachers, but that union is a small union, local, that is associated with the steelworkers union and construction workers unions and auto worker unions under this large umbrella. So even though there are small chapters for unions, there is this national kind of influence. But that's not the same as having a national union like some labor workers do in other countries. Much more fragmented in the US, probably limiting the union's ability to coalesce politically and coalesce financially to have that same global influence that they do in other countries. All right, next let's talk about the legal system in the US. In the US, we use common law as our primary means of creating law. This means that law is made by judges. So the judicial system is where we get this common law, determined and enforced by common sense lay judges to create a legal system with predictable outcomes. This common law originated in medieval England around 1200 and spread to the British colonies. It's a type of law that is based on custom and precedents, not a written legal code. So let's be clear. What we get from the House of Representatives and the Senate in Washington, or what we get from the legislature in Sacramento or the city council in San Diego, that is civil law. That's codified law. And even though that is a part of our system, there's a bigger part that is common law. So you never have one or the other, civil or common. It's always a ratio. And in the US, we tend to gravitate towards more common judge-made law than civil government-made law. It's based on the principle of judicial precedent. That means that court decisions should be consistent with past decisions. Let's say you have two parties that are in a dispute. Let's say one party hit another party's car and damaged it. Well, the judge has to look at the case, the circumstances of the case, and using a reasonable man perspective, decide on what the best course or remedy is. And likely, If we're using a reasonable perspective, the judge will say, well, if one person damaged another person's car, then they need to pay that person for the damage. They need to indemnify them, that is, make them whole again. I think most of you would agree that that would be a reasonable person perspective, a common sense kind of adjudication. Okay, well, that would set a precedent. And then subsequent courts that are hearing a case that is similar, although maybe not perfectly identical, but similar to that, would then refer to that previous case as precedent. They would in effect be bound by the lower court rulings so that there is a consistency in adjudicating disputes within the overall economy. Common law systems tend to be malleable over time. That is, they change with the contemporary circumstances that are necessary. This is a form of spontaneous order. We get rid of inferior laws and replace them with more relevant laws. I mean, go back and look at some of the laws that were on the books, 100 years ago or even 200 years ago in this country, and you'll be shocked that we would even have them anymore. And within a common law system, those laws have long gone away. They're simply not being enforced. But in some jurisdictions, you might still have codified law that has those laws on the books, and they could be enforced. So spontaneous order allows us to do what we do with other institutions in our system, get rid of the bad ones and replace them with the good ones. All right, let's wrap up with the government transfers and the tax system. In the U.S., we do have transfer programs. These are sometimes called entitlement programs. Just means it's a transfer from one party to another through government based on some qualifying need. So Social Security, welfare, TANF is temporary aid to needy families. That's the welfare program, unemployment compensation, and a whole host of others. These entitlement programs really got traction during the Great Depression and FDR's New Deal. He put a lot of people to work through the Public Works Administration. He created unemployment compensation so that people could keep spending and buy those basic necessities and keep the economy going when they lost their job, and a whole host of other social legislation to help us recover from the Great Depression. One of those pieces of legislation was the Social Security Act. This created the largest pension plan in the country. Once you turn 67, you will be entitled to, assuming you've met the minimum work requirements, a pension for the rest of your life from the federal government. The Social Security Act was amended in 1954, adding disability. So today, people can collect Social Security before they turn 67 if they are permanently disabled. Johnson's Great Society is another one. This came around in 1965, creating Medicare. Medicare is that famous health care plan for people over the age of 65. So created in 65 and for those over age 65. This was really the first single payer healthcare system in the US, but again, it only applies to people over the age of 65. And then the Affordable Care Act of 2010, also known as Obamacare. This one set up subsidized healthcare exchanges, which some of you may be familiar with. You have to buy healthcare in this country. Otherwise, you could be penalized, although there have been changes since 2010 that have mitigated some of those penalties. But generally speaking, the goal is to get people to buy healthcare, and it set up these healthcare exchanges to vet people based on their ability to pay. So if you make a lot of money, you're going to pay the full price. But if you make less money, the government starts to step in and cover some of that, and in some cases may even pay the whole cost of your health care. It also required insurance companies to cover those that have pre-existing conditions. Let's wrap up with the tax system. In the US, the tax system is primarily income, corporate, and payroll taxes. Now we're talking about the federal level here. Income taxes are based on your income due April 15th of the subsequent year. Corporate taxes are a separate system assessed on corporate profits, and payroll taxes come out of your paycheck. So you know of these as your FICA taxes. Look at your pay stub next time, and these are used to pay for those programs, Social Security and Medicare, that you get when you get older. The income tax didn't even exist in the US until we amended the Constitution via the 16th Amendment in 1914. So that kind of tells you about our tax history. It was abnormally low compared to many other countries. And that stands today. One of the things that makes the US model unique is the low tax environment. We do, however, have progressive taxes, meaning the more you make, the more you pay on average. All right, that's it, guys. If you have questions, let me know.